All right. We're now going to turn to item 9, which includes 9.1 through 9.5. All right. So these agenda items consist of 1, proposed cease and desist order CCC-23-CD-05 and administrative penalties CCC-23-AP-04 and CCC-23-AP3-01 for the Rio Del Mar Beach Island Homeowners Association for the property known as the 37-foot walk and beach drive, as shown on the map of subdivision number 8, Aptos Beach Country Club Properties, recorded in the official records of Santa Cruz County in volume 24 of maps at page 26, as well as Seacliff State Beach. 2, proposed cease and desist orders, CCC-23-CD-06, and administrative penalties, CCC-23-AP-05 for the Guare Singh and Sonal Puri, known as the Singh Puri Living Trust, for property located at 202 Beach Drive, Aptos, Santa Cruz County, as well as the 37-foot walk, beach drive in the immediate vicinity of 202 Beach Drive, Santa Cruz County, California. Would the alleged violators and/or their representatives identify themselves for the record?
Thank you, Madam. Sorry. Thank you, Madam Chair, Commissioners. My name is John Erskine. I'm a partner at Nossaman LLP. I'll be introducing my partner, Patrick Richard, who is a partner in our San Francisco office, who will do the bulk of the presentation on this matter. And the reason Patrick will be doing it is because this has a parallel track in litigation. We were in court this morning. He may mention that, but we're here representing the 27 beachfront property owners and Gaurav Singh and Sonal, the owners of 202 Beach Drive. Thank you.
Thank you. So that's Patrick Richardson. Just
Sorry.
if you'd like to just introduce yourself and
Yeah,
then we'll
good
proceed.
afternoon. I appreciate the opportunity. Patrick Richard. I have two first names.
Richard. Okay, thank you very much.
That's not a problem. Thank you.
All right, appreciate it. Staff, can you please identify what items are already part of the record and how much time would you like for your presentation and rebuttal? And who will be presenting? Ms. Hagee.
Thank you, Chair. The record consists of the contents of the staff report and supporting documents, the 2 appendices, and the addendum, which contain letters of support for this enforcement action from a number of parties, which we listed in the addendum. I won't read them here. Additional materials received from counsel from respondents received over the last week and this weekend, and staff responses there too. And we would take 55 minutes, please.
All right, thank you. So we will be giving you 55 minutes for your presentation, and likewise, we will be giving 55 minutes to the alleged violators to respond. There should not have been any ex parte communications, but do any commissioners have any such communications to report? All right, seeing none, I will now review the rules for this proceeding. Staff has asked for up to 55 minutes for its presentation, so I'll give the alleged violators, as I just mentioned, together the same amount of time, and they may also request to reserve some of that time for their own rebuttal, and we will allow 3 minutes for any other party who would like to speak as an interested member of the public. Anyone who speaks at this hearing may propose questions either orally or in writing that they would like commissioners to ask of any other party, but it is not appropriate to suggest that questions be asked to yourself. Commissioners may, but are not required to, ask the proposed questions. All right, we are now going to open and begin the public hearing with the staff presentation. Ms. Hagee.
I'm sorry, my script said good morning. That's hilarious. Good
Did I
afternoon.
just say good morning? Oh,
Good
good. I
afternoon.
didn't think I said good morning because I pretty much know what time it is.
I'm just an optimist at heart. Good morning, Chair and members of the Commission. Staff would now like to present agenda items 9.1, 9.2, 9.3, 9.4, and 9.5. And as you noted, they share a single combined staff report. And on this slide, you can see a photo of the unpermitted barriers and fencing that currently blocks public access to a beachfront walkway in Aptos here in Santa Cruz County. This walkway is immediately adjacent to the beach in a very popular coastal area. And I also note that this walkway is important for use for parents with strollers and all kinds of less able persons. This walkway has been the subject of enforcement efforts off and on for decades, as you will hear. Given the passage of time and the current positions taken by respondents, staff has spent an enormous amount of time looking into and documenting the historical, legal, and factual record for this site, as you will see. But just to speak plainly for a minute, the alleged violators have raised many collateral and irrelevant issues, which we will still summarize and respond to. But this is at heart a simple case of enforcing permit conditions for public access and habitat in a permit issued by this commission. Today's presentation will be given by Rob Montalwag, who is the lead headquarters enforcement attorney in this case, as well as by headquarters enforcement supervisor, Counsel Justin Burr, Assistant General Counsel Alex Halperin, and Commission ecologist Dr. Rachel Pausch. Also available for questions is our staff engineer, Jeremy Smith. Rob? I know this is going to work.
Good afternoon, Chair Hart and members of the commission. Next slide, please. On this slide, you can see the walkway at the center of these cases, which is located on the beach in Aptos. It is nearly a quarter of a mile long, and there are 29 houses on the inland side of it, several of which you can see on the left in this photo. You can also see some of their patio furniture in the walkway. On the right, you can see a revetment that is mostly covered with ice plant. The first alleged violator in this case is the Rio Del Mar Beach Island Homeowners Association, which covers most of the houses in this area and which I will refer to as the HOA. The HOA members mostly operate their houses as short-term vacation rentals, and this photo is taken from VRBO, the short-term vacation rental website. The HOA applied for and received a CDP in 1980 to build the revetment on the right. As you'll hear today, this CDP included a number of conditions, including a requirement to preserve public access to this walkway and to maintain native sand dune plants on top of the revetment. However, the HOA has precluded any required public access to the walkway and installed barriers at both ends, as you saw on the last slide. And as you can see on the right, the revetment is covered with ice plant, which is not native. Next slide, please. In this slide, you can see the upcoast portion of the walkway along with the house at 202 Beach Drive. The photo on the first slide in this presentation was taken looking at the same area, but from the other direction. The owners of this house are separate alleged violators, Gaurav Singh and Sonal Puri. Their property was not an original member of the HOA, but they've coordinated with the HOA to block public access to the walkway with barriers underneath their house, where people used to access it. In addition, Singh and Puri have maintained an unpermitted seawall and other unpermitted development in front of their house. The seawall is visible on the bottom left of this photo. Singh and Puri share the same legal representation as the HOA and have similarly refused to address their violations. There's a lot to cover in this presentation, so we'll do our best to tell the story in chronological order. I'll first provide information on the location and background history of the houses. Commission Headquarters Enforcement Supervisor Counsel Justin Burr will then explain the permit history of the HOA's CDP and its conditions. I'll then cover the public access violations at issue, including Singh and Puri's unpermitted seawall, and Commission District Enforcement's efforts to resolve this matter. Then, Commission ecologist Dr. Rachel Pausch will walk through the violations involving invasive ice plant on the revetment. After, I will detail the headquarters enforcement efforts to resolve this matter and our cease and desist order and administrative penalty recommendations. Finally, the Commission's Assistant General Counsel Alex Halperin will provide responses to some of the alleged violators' many arguments. Next slide, please. The properties at issue are located in Aptos, in unincorporated Santa Cruz County. On this map, you can see that Santa Cruz County, where we are today, is located close to the urban San Francisco Bay Area. Next slide, please. On this slide, you can see the beach boardwalk in Aptos, outlined in black, that stretches for almost 2 miles adjacent to Seacliff State Beach. However, near the middle of this boardwalk is the subdivision called Rio Del Mar Beach Island, where public access to the beachfront walkway is blocked by the HOA and Singh and Puri. Next slide, please. This map shows the approximate location of the parcels that make up the HOA, outlined in red. The parcel owned by Singh and Puri at 202 Beach Drive is the one furthest to the top left of this map and was not an original member of the HOA. The rest of the parcels outlined extend from 206 to 300 Beach Drive. You may notice that one parcel, in between Singh and Puri's and the HOA parcels, is not outlined in red. The owner of that parcel, at 204, has complied with our request to not obstruct public access to the walkway, has not opposed public access, and is not a member of the HOA. Therefore, Commission staff are continuing to work with the owner of 204 to bring an amicable resolution to you in the future. Next slide, please. This photo shows the famous cement ship at Seacliff State Beach. The beach is very popular and draws many visitors. Next slide, please. In this photo, you can see the beach boardwalk as it passes over Aptos Creek, just up coast of the properties at issue. Next slide, please. This slide shows the boardwalk as it looks just down coast of the houses at issue. You've now seen both boardwalks at either side of the subdivision, but this case addresses what's in the middle. Next slide, please. In this photo from about 1930, the arrow is pointing to the subdivision that you just saw a parcel map of. The houses haven't been built yet, but there's cars parked in what is now the walkway. In the top left of this photo, you can see the bluffs above the sand, and on the right, you can see the ocean. The subdivision was built in a location very prone to wave action. While it's not legally relevant to the proposed orders today, you may find it helpful to know that in the late 1920s, the original developers dedicated public rights-of-way on both sides of the subdivision to the county, including one on the oceanfront side that they called the 37-foot walk. The Board of Supervisors voted to accept the dedications. Next slide, please. This 1979 photo shows a few of the most upcoast houses in the HOA. This photo and others show that the upcoast entrance to the walkway, which is circled in yellow, was open to the public then. Next slide, please. Now we're going to discuss the events that led to the CDP at issue in this case. In this photo from 1980, you can see where waves knocked almost half of the width of the walkway into the ocean. Next slide, please. Here's another angle of the damage. The 12 feet of walkway width closest to the houses did survive the storms, but the 8 feet nearest to the ocean was lost. We're now going to show another photo taken from the exact same angle just a few days later. Next slide, please. This slide shows an emergency revetment built in front of the remaining portions of the walkway. This photo is most interesting for another reason though. Next slide, please. On this slide, you can see a photo taken in 2018 of a dark fence with large wood posts that was built at the down coast end of the walkway in 1982, as we'll discuss in later slides. On the left, you can see the brick house next to it at 300 Beach Drive and the fence that extends on top of some of the bricks. Keep looking at the brick house as you'll see it also on the left of our next photo. Next slide, please. Now here's a zoomed in version of the same photo we just saw from 1980. The brick house is to the left of the yellow circle. The area circled in yellow is not blocked by a fence. As we saw earlier, the upcoast entrance to the walkway was open as well. This is important because only a couple weeks after this photo was taken, the HOA applied for the CDP at issue here. I will now turn it over to our Headquarters Enforcement Supervisor Counsel Justin Burr, who will discuss the CDP. Next slide, please.
Thank you, Rob, and good afternoon, Commissioners. On March 13th, 1980, the HOA applied to rebuild the 8 feet of walkway width that had fallen into the ocean and to rebuild a revetment in front of the rebuilt walkway. Then, on March 24th, Commission staff issued a report which noted that the proposed revetment would be located on an existing 37-foot wide public easement. The Commission also noted in that report that historically a 20-foot wide concrete walkway had been used by the residents as private decks. Next slide, please. Here in this slide is one of the exhibits to the 1980 staff report. You can clearly see that the Commission understood the area shaded in purple to be encumbered by a public easement. Also note that the easement is shown extending seaward of the houses at 202, now owned by Singh and Puri, and 204, which is not a part of the case today. Thus, the Commission considered the public access and the conditions regarding it to apply to the entire walkway, not just the walkway seaward of the houses that were part of the HOA. Next slide, please. On this slide, you can see the letterhead from a county encroachment permit. The day after the Commission issued their staff report, the Board of Supervisors authorized the HOA to build a revetment on the most seaward 17 feet of the 37-foot walk. The county's encroachment permit stated that the HOA could only build the revetment on the condition that the public shall have a right to use the walkway along the whole length of the 37-foot easement, which shall be preserved. Next slide, please. During the CDP hearing, staff explained that it doesn't appear that the seawall will encroach on the public beach, nor will it cover up any existing public access ways. This statement by staff makes sense because the revetment would be seaward of the walkway, but inland of the sandy beach owned by state parks, and the action taken by Commission relied on this fact. Next slide, please. Accordingly, in this context, the Commission imposed Condition 1 of the CDP to allow the HOA to construct a revetment, but required the HOA comply with all necessary conditions of local approvals, and specifically named the encroachment permit. Rather than require the HOA to record a new easement that would be duplicative of the old one, the Commission simply incorporated the county's encroachment permit requirements into the Commission's permit by reference. Next slide, please. The Commission was not only concerned with public access here. Commissioner Garcia at the hearing stated that, quote, "The applicant's representative mentioned in his presentation that they would be planting the dunes with ice plant, and I don't think that would meet the Condition 9, which calls for species native to the dunes of Monterey Bay," end quote. The hearing room actually laughed at this comment, as it was well known even in 1980, the ice plant is an invasive species harmful to dune habitat. The executive director and the chair of the commission both then confirmed that the planting of ice plant would not be in accordance with Condition 9 of the CDP. Next slide, please. We are now going to briefly cover some of the conditions the commission imposed related to the revetment. Condition 5 requires that the HOA use only clean rock and not use any foreign materials such as concrete. Condition 5 also requires that the HOA ensure that the revetment does not migrate seaward onto Seacliff State Beach. Next slide, please. Condition 9 requires that the HOA cover the revetment with sand and maintain native plants in good condition on top of it. Next slide, please. Condition 8 requires the HOA to submit monitoring reports for the revetment every 2 years for review and approval of the executive director. Next slide, please. With that background, now I will provide a brief historical account of Condition 1. This is important because the HOA contends that nobody ever thought that Condition 1 required public access. Following approval of the 1980 CDP, the HOA formally incorporated, and the HOA's original bylaws from that same year stated that, quote, "The seawall shall be primarily for the benefit of the benefited parcels, and secondarily for the benefit of the public." This shows how the HOA understood the CDP as requiring the HOA to preserve public access to the walkway. There is no other benefit to the public that the revetment could possibly provide here other than to protect public access to the walkway behind it, which at the time, next slide, please. Then in 1981, after staff sent a letter to an HOA member who built an unpermitted stairway in the revetment, an attorney responded on their behalf and argued that their stairway would be open to the public. It is important to note that this attorney, Jeffrey Van Looks, was also an HOA member himself and also acted as the representative for the HOA in the 1980 CDP hearing we just covered. Van Looks pointed out that, quote, "A specific requirement imposed by the commission on the homeowners and a condition to the issuance of the permit was that nothing be done to limit or reduce public access," end quote. Thus, the HOA's own representative understood that any closure of the walkway would be a violation of Condition 1 of the CDP. Next slide, please. Here on this slide, you can see a CDP amendment that was approved a couple days after commission staff received the letter just discussed. Staff approved an immaterial amendment to allow the HOA to install stairways made of rock in the revetment that are only 3 feet wide. However, as we will explain more in detail later, none of the stairways as they exist today within the revetment are built consistent with the requirements of this CDP amendment. I'll now turn things back over to Rob to address the violations at 202 Beach Drive.
Next slide, please. This slide shows plans for a seawall at the upcoast portion of the walkway from 1981. The arrow is pointing to what the plans refer to as the proposed wall, shown in the long dotted line that goes from the top left to the bottom right of the plans. The star on the plans shows where the house at 202, which is currently owned by Singh and Puri, is today, but at the time no house yet existed. A prior owner of the undeveloped lot at 202 submitted these plans to the county in 1981, which approved them and issued that owner a building permit. However, the county did not yet have an LCP, and so could not and did not issue a CDP. The owner of this house did not apply for or obtain a CDP, and so this seawall remains unpermitted. Next slide, please. A picture taken this year shows the unpermitted seawall that you just saw the plans for. We'll discuss the construction of the house at 202 in a few slides. Next slide, please. This photo was taken standing next to the Beach Drive sidewalk. On the left, you can see Beach Drive. You can also see that the unpermitted seawall built in 1981 extends all the way to the unpermitted orange barriers along the Beach Drive sidewalk. Even if the orange barriers visible in this photo stayed there, The public could still access the walkway from the sidewalk if this part of the seawall were removed. Thus, this seawall is not just blocking public access because it causes the beach to shrink when waves hit it. This unpermitted seawall is directly blocking public access to the walkway from this sidewalk. Next slide, please. Just to reiterate, the close-up plans from 1981 also show the proposed wall as it exists today, including the steps built into the seawall that you can see in the center. Next slide, please. Here you can see the steps built into the seawall in cinder block are clearly visible in this photo, just as they were in the 1981 plans. You can also see an unpermitted orange barrier placed to stop the public from accessing the walkway. Next slide, please. You also may have noticed that the 1981 plans show an existing wall on the inland side against the Beach Drive sidewalk, but that there's a large gap in the wall shown, which is now circled in yellow. This gap in the wall further illustrates how this walkway was open. This entrance to the walkway was open at the time of the commission's considering of the CDP. This entrance actually stayed open all the way up until it was closed off by barriers placed by the HOA in Singanpuri in January of this year. Next slide, please. However, as you can see on this slide, a fence was built at the down coast entrance in 1982. In 1982, the HOA allowed a fence and concrete footing to be constructed that blocked public access to the down coast side. Note that on the bottom left, you can also see a railing and separate concrete curb built by the county in front of part of the fence. The small yellow circle, though, shows where we are now going to zoom in to take a closer look at the concrete footing that the fence is built on top of. Next slide, please. This photo shows that the concrete footing under the fence has the number 1982 carved into it because that is the year it was built, long after coastal permit requirements came into effect in 1972. You can also see the county's separate curb in front of it on the left-hand side of the photo. The county later removed this fence, as we will describe later, but the unpermitted concrete footing with this inscription is still out there today. Next slide, please. In 1988, the owner of 202 applied to the county for a CDP to build a house on that parcel. The county found that the 202 parcel is surrounded on 3 sides by pedestrian and road easements, including the walkway at issue. Next slide, please. This 1993 photo shows how the county required the house to be built on piles that were 17 feet above mean sea level so that it can withstand coastal flooding. Because the house was elevated, this also ensured that the public could walk under the house in the area circled in yellow in order to access the walkway from the upcoast side. In 1993, the owner of the house applied for a CDP amendment for additions to the top of the house. The applicant also applied to use part of the walkway as a private parking space. Next slide, please. Oh, sorry, back. I'm sorry, I went ahead of myself. If you could go back to 39, thank you. The county did issue the applicant a CDP amendment for their proposed development on top of the house. However, the county rejected the applicant's request to use the walkway as a private parking space. The county found that, quote, establishment of a parking space within a dedicated public walkway would conflict with any future use by the public. Quote. Next slide, please. Now I'm ready for 40. In this photo from 2002, you can see invasive ice plant on the revetment. The 1998 El Nino winter caused the HOA to apply for an emergency CDP to add more boulders to their revetment. Staff was unaware of the violations and so issued an immaterial amendment for those boulders in 1998. However, the HOA added many more boulders, some unpermitted, and some pursuant to an emergency CDP in 2002. That same year, staff became aware of the 1980 CDP violations as well and opened this case. Next slide, please. In 2002 and 2003, Commission planning staff notified the HOA of their violations. Staff then attempted to resolve these violations via a CDP amendment. Next slide, please. At the time, the HOA did not dispute the CDP's public access requirements. In 2003, the HOA wrote back and stated, quote, the walkway is open for public access across its entire length, unquote. The HOA also did not dispute the conditions requiring planting of native dune plants. The HOA did say, though, that they prefer the ice plant, and instead of proposing to remedy the violation, the HOA proposed to, quote, fill in any current gaps in the landscaping with more ice plant as needed, unquote. Then talks to resolve the violation broke down. In the early 2000s, the Commission did not yet have the ability to issue administrative fines, so staff were often unable to resolve violations. Next slide, please. In this photo, you can see the upcoast entrance to the walkway in 2011, circled in yellow. In 2009, a prior owner of 202 applied to the county for a CDP to build a fence and gate underneath their house in order to block the public from accessing the walkway. The proposed fence and gate would have completely filled the area of the yellow circle. Next slide, please. Again, the history supports that all parties here realized that this was a public access way. One of the HOA members wrote to the county in opposition to the proposed fence and gate. They stated that, quote, "Our family has used this pathway for many, many years with babies in strollers, toddlers on tricycles, elders with canes, walkers, and wheelchairs. This is a much safer, wider, and easier route than the very small and tight sidewalk on Beach Drive itself." Their letter also stated that they were, quote, always under the impression that this was a public right of way, unquote. Next slide, please. This photo shows the narrow sidewalk, which the HOA member was referring to, along Beach Drive on the inland side of the houses. This is the sidewalk that the public is now forced to use because of the HOA and Singapuri's violations. There's no ocean view from this sidewalk. However, most importantly, you can see the waste containers that make this sidewalk even narrower. These containers are not only placed there on trash day, but are permanently stored there by members of the HOA. This is despite the fact that in other cities with houses that fill their entire private parcels, property owners simply create indoor storage areas for their waste containers. The presence of these containers is not a violation of the 1980 CDP, but their permanent placement is unpermitted development and causes the sidewalk to be unsafe or unusable for disabled persons, as the HOA member themselves pointed out. Staff therefore recommends that the Commission order the HOA to direct their members to comply with local ordinances and remove this unpermitted development. These violations by individual HOA members also remain subject to future enforcement action. Next slide, please. Over time, the county remained concerned about preserving public access to the walkway. The county approved the prior owner of 202's request for a gate and fence under the house. However, it conditioned this CDP on the owner removing the wall next to the house so that the public could still access the walkway. But the applicant never signed the permit, it never became effective, and the status quo remained. Next slide, please. I'm now going to describe enforcement staff's efforts to resolve these violations. This photo shows some of the unpermitted patio furniture placed in the walkway by HOA members. In 2014, the Commission obtained the ability to issue administrative penalties for violations of the public access provisions of the Coastal Act and began reviewing cases that might be resolved using this deterrent. In 2017, district enforcement staff sent notice of violation letters to all of the property owners in the subdivision, including every HOA member. The notices explained that they were liable for both violations of the 1980 CDP and for their unpermitted development. Next slide, please. Following the notices, most HOA members initially cleared out their obstructions to public access to the walkway. However, some refused, such as the owner of this house at 300 Beach Drive. You can see his unpermitted patio furniture and rope here. Staff sent many letters back and forth to the HOA in 2017 and 2018, and also attempted to coordinate with the local government, as is our standard practice, and who here asserted that they held a public easement over the walkway. But towards the end of 2018, the HOA obtained a new legal counsel, and talks regarding a potential settlement broke down. Next slide, please. In 2018, several HOA members sued the county, alleging that the HOA owned the land underlying the walkway and that the county held no easement or any other property interest. Afterward, the county removed the wall next to the house at 202, which had been substantially modified with an unpermitted fence built on top. In addition, the county removed the unpermitted fence at the downcoast end of the walkway that had been built in 1982. This meant that the walkway was open at both ends for the first time since the HOA allowed the unpermitted fence at the downcoast end to be built in 1982. Next slide, please. This slide shows a quick, maybe not that quick, list of letters back and forth with the HOA from 2017 to 2022, which indicates the effort we put in to trying to resolve this matter amicably. As you can see, Commission district enforcement staff did not give up. Again, we note that the CDP created a Coastal Act requirement for the HOA to preserve public access to the walkway, regardless of whether the county ever owned a property interest there. Next slide, please. Here's a shot of the downcoast entrance to the walkway after the fence was removed. You can actually see that the unpermitted concrete footing and fence posts built into that footing are all that remains of it. In 2022, a trial court ruled that the county does not own any property interest in the walkway at this time and stated that the HOA could replace the removed fences. However, the judge acknowledged that the commission was not a party to the litigation. To avoid any confusion about separate Coastal Act and CDP requirements, staff reached out to the HOA and told them that the CDP required them to preserve public access to the walkway regardless of ownership, and also that any fence would require a CDP. Next slide, please. Here you can see the upcoast entrance to the walkway after the wall was removed. In 2022, I took the lead on these cases. Next slide, please. On January 16th, 2023, following storm damage, the HOA erected barriers at both ends of the walkway and across all of the unpermitted stairways in the revetment and unpermitted seawall. This photo shows the fence at the upcoast end. Next slide, please. This photo shows how the fence at the upcoast end extends onto the 202 parcel and underneath the house, closing off where people used to walk under to access the walkway. Next slide, please. This photo shows the fence erected at the downcoast end. Next slide, please. And finally, this slide shows another angle of the fence at the downcoast end. In this photo, you can also see that some of the signs state that the area is, quote, closed by order of Santa Cruz Superior Court, unquote, although that's misleading at best. The court did not order the HOA to take any actions, post any signs, build any fence, or close any area. Even if the HOA owned the walkway, they could still comply with the CDP and preserve access for the public. Next slide, please. In this photo, you can see members of the public being kept out of the walkway by the barriers. Headquarters enforcement wrote to the HOA and Singanpuri's representatives to explain that the barriers were unpermitted and that liabilities were accruing. I'll now turn it over, though, to Commission Ecologist Dr. Rachel Pausch to discuss some of the ecological issues relating to the violations.
Good afternoon, Commissioners. Next slide, please. This slide demonstrates that most of the plant cover along the revetment is composed of non-native European sea rocket and invasive ice plant. Ice plant is a non-native invasive species from South Africa that is detrimental to habitats in coastal California, especially in Santa Cruz County. It grows in thick mats that exclude native plants from growing, which can adversely affect pollinators that rely on native plants flowering throughout the year. Ice plant can also degrade foraging shorebird habitat by completely covering the sand with thick mats, and in some cases even negatively impacting soil biochemistry. Next slide, please. Maintaining native plants in good condition on top of this revetment, as the original CDP required, likely would have replaced some of the lost ecological functioning resulting from the development. Native plants that could be planted to comply with this condition include, but are not limited to, beach burbing, sand verbena, and saltgrass. I'll now turn it back to Rob, but I remain available for questions.
Next slide, please. And here's one of the unpermitted private stairways built into the revetment. Although an immaterial amendment approved some stairways in 1981, that was only for rock stairways, not concrete. Also, so many boulders have been added to the revetment without a CDP since 1980 that the revetment is now several feet higher than originally permitted, and therefore, this stairway must also have been built relatively recently and not pursuant to the 1981 amendment. All of these materials are also in violation of Condition 5, which requires that the revetment only include clean rock and not concrete. Next slide, please. On this slide, you can see an ad on the short-term vacation rental website Airbnb for the house at 202 owned by Singanpuri. Their ad explains that there's a gate on their property that guests can use to access the walkway, but that guests are required to keep the gate locked. Next slide, please. This screenshot shows the instructions for guests in the Airbnb ad. The ad states that other houses, presumably all HOA members, have keys to the gate so they can use the walkway as well. The ad also states that the city has blocked public access here, which is not true. Aptos is not even an incorporated city, and the county certainly did not block public access here. Next slide, please. On this slide, you can see another list of communications. Just before we notified the HOA and Singanpuri's representatives that we would be going to hearing this month, we spent a lot of time trying to resolve this and sent many letters. In May, we tentatively scheduled this hearing for August, but delayed our plans to try and reach an amicable resolution. In July, we sent them a settlement offer, but they refused to discuss any resolutions that involved providing public access. Thus, over 20 years after staff first attempted to resolve these violations amicably, we began preparing for this hearing. Next slide, please. Here's another ad for Singanpuri's house at 202, advertising the private walkway and furniture. Most recently, Singanpuri and the HOA have argued that the walkway may be unsafe and so should not be used by the public. Yet, as you just saw in those vacation rental screenshots, they are still letting paying guests use the walkway. All of this privatization of a walkway that's supposed to be public is a clear environmental injustice. Persons with disabilities cannot safely use the sidewalk on the inland side of the houses because of the HOA members' unpermitted waste container storage. Meanwhile, paying guests of Singanpuri and the HOA members enjoy exclusive use of the beachfront walkway that you see here, and it also impacts low-cost recreation and coastal views. Next slide, please. The fences erected by the HOA in Singanpuri and their maintenance of the seawall constitute development under the Coastal Act, but no CDP was obtained. In addition, the HOA failed to comply with many of the conditions of the 1980 CDP. Thus, as detailed in the staff report, there's a basis to issue a cease and desist order to bring the alleged violators into compliance. Next slide, please. The proposed cease and desist order to the HOA requires them to comply with Condition 1 by removing all of the unpermitted development in the seawardmost 12 feet of the walkway, including the barriers at both ends. In addition, the order would require that the HOA comply with Conditions 5, 8, and 9 by removing the unpermitted private stairways and other foreign materials from the revetment, removing the invasive ice plant that stops native plants from going, and installing native vegetation. Further, the order would require that the HOA direct their members, to the extent they can, since it's not a CDP requirement, to stop storing unpermitted waste containers in the sidewalk and to remove unpermitted high-intensity lights that shine on the beach and ocean and disturb native wildlife. Next slide, please. In this photo, from shortly after the notices of violation were sent, the walkway is mostly free of obstructions, and so this photo is a preview of what the order would require. All obstructions to the left of approximately the yellow line would be ordered to be removed. Nearly all of the balconies appear to be within approximately 8 feet of the houses to the right of the yellow line, and although many appear to be unpermitted, staff's recommending not to order them out at this time as an accommodation. Next slide, please. The proposed order to Singanpuri would require them to remove all unpermitted development from the 202 parcel, including the fencing and barriers built under the house to block public access to the walkway. In addition, Singanpuri would be ordered to remove the unpermitted seawall that negatively impacts the beach and directly blocks access to the walkway from the sidewalk. However, if an entity managing the walkway in the future, such as the county, requests to use portions of the seawall to preserve public access, the executive director could find that portions of the wall are necessary for that, and so those would stay. However, any portions of the seawall not removed would still be unpermitted. And further, if there's no public access justification, all parts of the seawall would be ordered to removed in their entirety. Next slide, please. And on this slide, you can see a photo of the seawall. The portions of the wall on the left are less necessary from a coastal hazards perspective, but they're directly blocking public access to the walkway from the sidewalk. In addition, you can see that plants are growing on the sand in front of the seawall. Just up coast of here, state parks use sand and driftwood to successfully defend public bathrooms during last winter's storms. Therefore, it is possible that a living shoreline project could be successful here as well, given the large amount of sand that comes from Aptos Creek just up coast. This would be especially true if the tile unpermitted walkway were replaced with something movable like a wooden boardwalk. And this is really the sort of analysis that would have been done if the seawall were ever considered for a CDP. And of course, the house itself is elevated on piles and built to withstand coastal flooding. Next slide, please. This is another photo of one of the unpermitted private stairways. A person or entity who's in violation of the Coastal Act is subject to penalties that may be imposed by the Commission. These penalties are calculated using factors on our next slide. Next slide, please. Section 30821 provides 5 factors in determining the amount of civil liability, which we have covered extensively in the staff report for all 3 different penalties that are recommended here. Next slide, please. On this slide, you can see the barriers at the downcoast entrance to the walkway. The HOA placed barriers to block public access at both ends on January 16th, 2023. Counting from 2 days ago, this is 330 days. The maximum penalty for one violation would therefore be close to $4 million, but we're recommending that the Commission issue a penalty of less than $3 million. Next slide, please. On this slide, you can see invasive ice plant and another unpermitted concrete private stairway built into the revetment. The Commission gained the ability to fine for violations of the Coastal Act not relating to public access on January 1st, 2022. It has been 710 days since then, as of 2 days ago. The HOA has violated 3 separate conditions of their CDP relating to the revetment. However, in an attempt to be conservative, staff is recommending that the Commission exercise their prosecutorial discretion and combine all 3 of those violations into one. The Commission could impose penalties of nearly $8 million for just one violation here, and nearly $24 million for all 3 violations, but staff is recommending a penalty of just under $2 million. Next slide, please. And on this slide, you can see the unpermitted orange barrier that blocks the stairway to the beach from Singanpuri's seawall. Although Singanpuri have maintained this unpermitted seawall and coordinated with the HOA to place barriers under their house to block public access, which constitute two distinct violations. Again, in an attempt to be conservative, staff is recommending the commission assess fines for only one violation. Staff is recommending the fine be from January 26th of this year, when we sent them a notice of violation for the barriers. Although the maximum fine for one violation for this time would be well over $3 million, and the 25% penalty would be nearly $1 million, staff is recommending a fine of just $500,000. I'll now turn it over to Assistant General Counsel Alex Helperin, who will conclude by discussing our responses to some of the HOA and Singanpuri's many arguments.
Thanks, Rob. I'm going to be briefly touching on what we've identified as the 6 main legal issues asserted by the respondents. Next slide, please. Those issues are the adequacy of the notice of this hearing, the fairness of the hearing more generally, how the burden of proof works in this case, mechanisms used by the Commission for ensuring public access, the Commission's jurisdiction to hear this matter, and the relevance of the homeowner's litigation with the county. First on notice, although the respondents claim that notice we issued was inadequate, they don't actually allege that it didn't meet the requirements of our regulations because they can't. The regulations, which are in sections 13181A and 13187, just require that we identify the property, the responsible party, and quote, a description of the activity, which we did. Instead, respondents frame this argument as a procedural due process issue, but the courts have said that the procedural due process is satisfied as long as respondents are made aware of the issues and given a reasonable opportunity to be heard. Next slide, please. Here, Commission staff issued a notice of violation letter in May that laid out every category of violation being addressed here today in a separate numbered point at the beginning and then again in bullet points in the body. An excerpt of the body of that letter is on the screen. We believe this provided a clear sense of the sorts of things we were claiming were violations. Nossaman has called the NOI scattershot, vague, nonspecific, and requested, quote, specific notice of details of asserted violations for each address. We addressed this in the staff report at pages 48 to 50, and we explain why using categories made sense here, but I'd just like to point out what Nossaman's suggestion would mean. Taking the third bullet as an example, you can see that it referred to patio furniture and fences in the walk that obstruct and discourage public access. Respondents' argument appears to be that we would be required to say, at address X, the furniture at issue consists of a wooden table of the following dimensions with 3 chairs. At address Y, the patio furniture consists of a metal table, and on and on. We don't believe that sort of detail is necessary to put them on reasonable notice. Moreover, we aren't pursuing the individual homeowners, so organizing it by address would not be relevant. The NOI was clear as to the three key issues highlighted on this slide: access to the walk, maintenance of the revetment, and the sidewalk obstructions. Nossaman only ever asked for clarification regarding one structure, stairs at 264 Beach Drive, and we said that as far as we knew, they were unpermitted. When they asked for more detail, we sent a letter explaining why they were unpermitted. That letter is Exhibit 85. Finally, as to the main issue, access to the walk, next slide, please. As you can see from the date on this letter, the HOA has actually been on notice of our position with respect to that issue for literally decades. Next slide, please. In terms of fair hearing, the violators have alleged that fairness of the Commission's hearings, other violators have challenged the fairness of Commission hearings in many cases. I think the most recent example was in response to the order this Commission issued 7 years ago to Valence, resulting in the 2022 Court of Appeal decision upholding the Commission's practice and authority. We discussed that case in the addendum, but the upshot is that the court found that your penalty assessment authority is not unconstitutional, either on its face or as applied, and that nothing in the Commission's procedures had violated their rights. As to the specific request to be able to examine witnesses, if the respondents have questions they want posed, they're free to propose them, as the chair mentioned, and if any commissioner finds that the answers would be probative of any material issue, the commissioner is free to pose the question. The Lent court specifically found that to be adequate. Next slide, please. In terms of the burden of proof, the respondents argue that we haven't carried our burden of showing that the subject structures lack the requisite authorization because many of them are either pre-coastal or received local permits. We addressed this at pages 54 to 57 of the staff report, but I'll recap a couple of points here. It's true that we have the burden of proof in an enforcement context, but let me explain why we've met that burden. With respect to the argument that some of the materials are pre-coastal, this picture is but one example of the photographic evidence we used, and I think it makes it pretty clear that pretty much everything out there that isn't right up against the houses, which are the only things that the orders require be removed, was installed after 1980. And there's no dispute that the barriers placed at either end went up just last January. In terms of proving the development at issue lacked a permit, there's only so much one can do to prove a negative. In general, it's enough to search the permit records, and if we don't find any permit, the burden shifts. But here, staff went well beyond that, searching through physical county permit records and giving respondents more than half a dozen opportunities to provide evidence of permits. You can see pages 9 to 10 of the addendum for a list of just some examples. I think I list 8 letters there of instances when we beseeched the respondents to provide some evidence of coastal development permit. They continually said we had them, that they had such evidence. We never received any. Next slide, please. In terms of mechanisms for requiring access, respondents have argued that had the commission intended to ensure access, it would have required an OTD, as they allege that that's the only way that you can impose an access condition. We addressed this at page 64 of the staff report, where we pointed out how untrue that is. Moreover, as this exhibit from the 1980 CDP staff report shows, it was undisputed at the time that an easement already existed, so it would have made no sense for the commission to require another one. But I want to make just one additional point on this. 2 of the last 3 orders that this commission issued, Paradise Point in September and the Worcester order in April, involved enforcing old permit conditions requiring public access. Taking Worcester as an example, the commission issued an order requiring the subject property to be conveyed for public use. Why? What was the basis for that requirement? A condition from a permit amendment from May of 1980, just 2 months after the permitted issue here. That permit didn't require an OTD to be recorded against the property, and indeed, there was no easement on the property. There wasn't even a deed restriction. The access requirement came from a permit condition, but that was enough for this commission to enforce it. Nor does it matter if the property at issue is private property. There are 2,000 private properties throughout this state with public access is required as a result of an action of this commission, only 60% of which involve OTDs. Next slide, please. In terms of enforcement jurisdiction, this too is addressed in the staff report at pages 50 to 51, explaining how the respondents imagine a delegation scheme that doesn't exist, but I also wanted to emphasize the limited scope of that argument. It's based on language in section 30810 about enforcement after LCP certification, but the commission will be considering the use of 2 types of enforcement tools today, penalties and CDO authority. Your penalty issuing authority derives from sections 30821 and 30821.3. Not 30810. And those sections only authorize the commission to issue penalties, so the argument doesn't even apply to penalty assessment. Cease and desist orders, in turn, can be issued to respond to 3 types of violations: permit violations, cases where someone failed to get a permit from the commission, and cases where someone failed to comply with an LCP. The commission can always enforce its own permits. The 11 Lagunita case affirmed that principle. And that's the central issue here. And the commission can always enforce with respect to the second category as well. Indeed, the commission is the only body that can issue CDOs for those 2 categories. So it's only the 3rd category of the second category on this slide where there's even the possibility of another entity doing any enforcement. For that one limited category, it's true that once an LCP is certified, local governments can enforce violations of their LCPs using their normal code enforcement authority, but that's automatic. It doesn't require any delegation by the commission. The closest the statute comes to talking about a delegation, and it's still not a delegation, is the other direction, where the local government can ask the commission to enforce its LCP. Or the commission can ask the local government to enforce its LCP, and if the local government declines, that also empowers the commission to act, and that's exactly what happened here. Finally, with respect to one small subset, respondents try to paint a picture of a history of delegation. That's the subset of violations prior to 2018. But that history only shows coordination, not delegation, and it's entirely about those pre-2018 violations, which aren't even at issue in today's hearing. The violations at issue today are the ones from 2022 and 2023, and there's never been any county involvement in enforcing those violations. Next slide, please. Finally, we expect you'll hear a lot today from the respondents about their litigation and the events from the 1920s through the 1970s, all in service of their attempt to show that the county holds no property interest in the walk. But whether or not the county holds such an interest is not relevant here. Indeed, it's hard to imagine how anything that happened before 1980 could really matter here, because even if those events established that the HOA held title to the walk free and clear, in 1980, the HOA obtained a permit, conditioned on compliance with 9 conditions, and it accepted that permit and the benefits that came with it. The law is clear that the burdens of a permit go along with the benefits, so they have to comply with those conditions, even if they imposed obligations on what was otherwise unencumbered property prior to the permit and placement of the revetment. The respondents may also mention the court orders, both the one from last year saying that the homeowners are allowed to erect temporary fencing and the updated one from this morning saying that they're allowed to erect permanent fencing. But neither of those orders required anyone to do anything. They said that they allowed it. Moreover, I attended that hearing on September 16th of last year, and the county asked the judge, and he confirmed that his order would only be vis-a-vis the county and that he wasn't saying anything about the Coastal Act. The court then issued its orders a couple of weeks later, after which I spoke with Mr. Richard and Mr. Erskine to explain that we would consider the erection of a barrier to require a permit. They argued that it would be exempt, but they agreed that they would make that case to our Central Coast permitting staff before doing anything, which they never did. Instead, they did nothing until after the big storms 3 months later, at which point they began to seek an emergency permit, but then abruptly abandoned that effort and erected the barriers without any authorization. And although the court order only spoke of replacing the fencing that existed before, as you can see from this photo, the barriers they erected extend under the elevated house at 202, where there had never been a wall before. That's when we decided that we would need to start formal enforcement proceedings. Thank you.
Next slide, please. Just this is the end, I promise. In our last slide, you can see the house owned by Singh and Puri and the barriers put up by the HOA and Singh and Puri, as well as the unpermitted seawall on the other side of the palm trees. In conclusion, we want to thank you for your attention throughout this long presentation. And now I'm going to turn to Lisa and we're ready for questions.
I'm going to hold my comments until the end.
Okay, thank you. Does that complete staff's portion at this time?
Yes, it does. Thank you.
All right, thank you. Thank you very much for that. Now the alleged violators or their representatives may address the commission, and I believe that's going to be Mr. Richard with no S. Is that right?
Yes. Thank
Okay,
you,
I got
Chair
it.
Hart.
Welcome to the commission.
So,
So, Mr. Richard, you're going to have 55 minutes.
yes, and so as a preliminary matter, I don't think 55 minutes will do it. We had asked that these proceedings be continued to allow us to review the single-space 70-page staff report and the 1,700 pages of supporting materials that we received 2 weeks ago. I would renew that request. This matter involves a permit issued 43 years ago that we're prepared to review, but in the interest of due process, we had requested a continuance, and we stand by that request. That would allow everyone time to review the blizzard of incomplete information we just heard. Further, staff had objected to our supplemental statement of defense, and that in and of itself raises a due process concern. We have the right to submit those materials, and objecting to those materials justifies a continuance of these proceedings. As I said, my estimate would be closer to 90 minutes. We'll see how it goes.
What?
I was just waiting for Chair to,
Thank you. I'm conferring with attorney behind. you.
thank you.
Go ahead,
Did
please.
I get my continuance?
No, sir, that will be declined.
Thank you.
And
Um,
55 minutes is the time. Thank you.
I do have a bit of a tough task here, no matter how thin you make the pancake, as one of my clients told me, there's always two sides. And so you've heard one
Excuse
side.
me, sir. Could we begin the clock, please?
And
Thank you.
I don't know where my PowerPoint, I was expecting to see that up on a screen. Do you all have a PowerPoint, Billy?
Hang on just a minute. We'll get everything together. Just give us just a minute here.
Sure. Just don't start my time until my PowerPoint's up.
Absolutely.
Yes.
You gonna open the curtains? Sure, why not? Can you let me know, Billy, when you're ready? Can we open the curtains? Question 1. Yes. Question 2, do you have the PowerPoint? Question 3, do we have the clock? We are ready for you, Mr. Richard.
Thank you.
With regard to the clock, we'll try to put that as much as we can in the corner, which Billy has just done. Thank you very much. All right, you can proceed.
Let me see if my clicker is working from here.
Just let him know and he'll
There we go.
advance your
Thank
slides.
you. I won't spend a lot of time on this. We're here on claims not against every homeowner, as the May notice indicated, but we're here on claims against the HOA and against 202 Beach Drive. I'm not sure where I should be pointing this, Billy.
You know, you can just say slide and he'll advance it.
Okay, slide, please.
Your clicker?
Got it. Oh, don't touch the clock. Freeze it at 54. So I wanted to give you an overview, commissioners, as to the topics I like to cover. In the 70-page staff report, there are obvious errors regarding the 202 Beach Drive unpermitted seawall, as it's described. There are staff errors regarding the HOA 1980 CDP, which I think all parties agree is the thrust of what brings us here. Does the 1980 CDP require what staff has told you it requires? I'll spend most of my time on that. Staff just touched on the Superior Court action. There was an actual trial last year, and there's a quiet title action that also dealt with the county's unconstitutional taking when they removed the wall and fence. Proceeding in the manner staff has requested would be unprecedented, other than the time that commission was reversed for ignoring a quiet title action in another matter. I'll briefly touch on violations of due process. We're entitled to a fair hearing. We're entitled to meet evidence with evidence, and the proposed penalties are contrary to law. This slide identifies our basic rights to address the issues and all evidence, and that this body does have the discretion and should continue matters under these circumstances. I'd like to begin with 202 Beach Drive, because the staff report says, and you heard this again here today, following the construction of the HOA's revetment, the then homeowners of 204 Beach Drive built their own seawall. On November 2, 1981, the County of Santa Cruz issued a building permit for a cinder block wall and footings in front of 204 Beach Drive and the future site of 202 Beach Drive. Now, if that's all you had was staff's description of the facts, you'd think that there was a new seawall and there was nothing there before that. However, when you look at the actual permit, the patio was not built. The patio wall, that short wall around the patio, was not built after 1980. It existed for decades before 1980. Staff didn't want to talk about it. The last comments you heard were nothing before 1980 matters, and that's just not true. The 1981 county permit was not for a new wall. It was to replace footings and to allow a new fence, a lattice fence atop that pre-existing wall. And the commission actually issued a CDP in 1981 to 204, 5 months earlier, for a seawall. So here's a historic photo. Homes started to be built in this area in the early 1930s. And you can see that up coast area, there was a wall, cement wall with a fence on top of it back in the 30s. The permit that was issued in 1981 by the county was not for a new seawall. It was to replace footing and build fence around patio. That's the document. That's evidence that came into trial last year in front of Judge Volkman. This is an actual slide from the trial. This was the drawing that was submitted with the application. There's the completed fence and wall, the fence around the pre-existing wall that was built after that. The testimony was of the county's planning director, who didn't think the diagram was clear, but it clearly shows that that area had been enclosed for many, many years. In fact, here's the wall and fence as it existed for many years after 1980. Here's another shot of it. That was not part of a 2-mile public boardwalk, as staff has repeatedly said to you. The facts tell us that it wasn't. Now, nowhere in the 1,700 pages of material did staff submit the actual coastal development permit issued in 1981. Here you can see it's June 1, 1981. This is in the materials we submitted. This is location for emergency permit, 204 Beach Drive. Work requested, place approximately 250 tons rock riprap as addition to island seawall. Not in the materials staff submitted. Just briefly touching on, oh, and the conditions, you might say, well, that 1981 CDP for the actual riprap seawall at 202 and 204 must have included a condition of public access. No, it didn't, and the conditions are set forth there. There was actually no condition for any further permit. This was a permanent CDP issued for that seawall. And what's also interesting about the 1989 uh, uh, permit that staff mentioned for the home to be built at 202 is it described that that project, building the home, the project does not conflict with any existing easement or development. It goes on to say no easements across the site. So this notion that folks could walk under the home, the private property, that's just counter to what staff understood and what the commission understood in 1989. That was private property. There was no easement. What they said, folks could, the phrase used is walk under the home. That's not consistent with the 1989 permit. What is consistent is in 1989, the findings of public access to the beach is available via walkways along the esplanade, which are adjacent to the northwest of the project area. No additional coastal access is necessary or appropriate due to the small size of the parcel. And as we'll see in the 1980 CDP bill issued to allow the revetment for the down coast homes issued to the HOA to rebuild patios, that same language about public access exists. That is, there's plenty of access up coast and down coast of the island. This notion that there was any express condition or any findings in the 1980 CDP is simply not borne out by the evidence. And I did hear one of the commissioners, I know you've had a full couple days. I was listening to some of the testimony on the housing. And at the conclusion, there were comments, and the comment that facts matter. And sometimes when we hear things that we know not to be true, it's bothersome. And we're going to go through the 1980 CDP now because the descriptions of that permit and the descriptions of those findings do not match with the actual facts. And I think that matters. So the claims against 202, and by the way, 202 is not and has never been a member of the HOA. So they're not bound by staff's interpretation of the 1980 CDP issued to the HOA. And the notion that the HOA has the authority to direct a private property owner to remove materials from their property, this HOA was formed solely for the purpose of obtaining the permit and owning and maintaining the revetment. It's not a HOA that has any authority over the homeowner's patios. And staff just completely jumped over that point. That one fact alone is going to, the court down the street is going to say, you just can't do this, apart from the fact that it's not in the 1980 CDP. So this is, staff's entire argument rests on a non-existent condition in the 1980 CDP. It doesn't contain any condition requiring public access. You can read it. The words public access do not exist. So when they want to talk about other permits that refer to public access, that's in the language of the condition. It doesn't even mention public access in any condition. And the one thing the parties do agree on, the staff's entire position about public access turns on one condition and one condition only, condition number 1. What was condition number 1? It was to obtain local permits and provide evidence of those, not even the actual permits, just evidence that you obtained those permits prior to construction. But here's how staff describes the 1980 CDP. And I just think, again, the chasm between the description, the claim, the argument, and the actual facts matter. The description at pages 4 and 10 quote, in approving the revetment, the commission specifically conditioned the CDP to require that HOA preserve public access to that walkway. Elsewhere, they say, page 10, the 1980 coastal development permit included a provision, which will be discussed further herein, that also required the preservation of a public access walkway within a 20-foot wide strip of land between the homes and the revetment. And if all we had were these two descriptions, if the 1980 CDP had been lost, if there'd been a fire, you'd say, well, clearly there was a provision specifically conditioning public access, a provision, a condition, specific. It's not in there. Instead, the condition is a general condition. Prior to the commencement of construction, applicant shall submit evidence to the executive director that all local permits have been obtained. E.g., for example, so their entire public access argument, they're asking you to just ignore the actual language in this 1980 CDP. They're inviting a lawsuit, to be honest. You can't go from E.g., negative declaration, grading permit, encroachment permit, to, well, that's a specific provision in the permit. Oh, well, no, it's not in the permit. You have to go look somewhere else at a county easement that we don't have the right to enforce and that the Superior Court has said did not exist. And that's why enforcement staff here today said it doesn't matter. It doesn't matter if there was ever an easement. Then what are they claiming was incorporated here? But when you look at the actual language, it just doesn't match up with the description that staff is putting forward. I think that matters. That's page 10 of the CDP. Oh, well, okay, if it's not expressly in the CDP, let's look at the findings from 1980. Again, the description, this is staff's description. Those findings go on to explain, however, that a 20-foot wide strip of the 37-foot wide walk, and I put it in bold because it is such a departure from facts. It should be concerning when a state agency is coming after citizens of the state on such a falsehood. Has been, and I'm quoting, has been paved to make it usable for public access. Where in the findings? My goodness, if that was in the findings in 1980, that, oh, this has been paved to make it usable for public access. And this project will leave that entire 20-foot wide strip available. So it will have no impact on public access. This is such a profound misreading of those findings. I'm going to go through it in some detail. Again, I have to proceed on the basis that the evidence matters, that right and wrong should turn on actual evidence, not what we think 43 years later should have been done or could have been done. At the time, staff left no ambiguity. Public access would appear to not be affected by this project, period. There's no because there. There's no reference anywhere to anything being paved. Goes on. These are the findings from 1980. The proposed seawall would be located up against the residences, leaving the beach, normally used by the public, free of impediments. It would not affect lateral access to the beach. Oops. Did I get ahead of myself? Probably. I think I'm stuck. Goes on to say in the findings. So there's no language about anything being done to preserve public access, even in the findings. It's saying the project, building the patios, and what it actually says is historically the area had been used as private decks. And this concept of, in the 1928 map, you see a reference to 37-foot walk. Staff showed you that today. That same 1928 map, although it refers to 37-foot walk, has words on the map. And the words from the county said, we accept the map, we do not accept the offers of public dedication thereon. So this is staff accurately in 1980 noting, we see a reference to a paper easement, but it's been used by the residences as private decks. There was no 2-mile boardwalk that went behind these homes, ever. Not then, not now, not in the 1980s. That is a fiction. And the other point that if it was so clear, everyone accepted that there was this 2-mile public boardwalk, then why is it that commission staff in 1980 said the county is exploring their interests in the easement and staff will report any new information at the commission meeting? The county wouldn't be exploring their interests if it was clear. This is a fact that the judge relied on when he noted the county never ever spent a penny on this purportedly public easement. It had been used as private decks for decades. The findings went on in 1980, and I set them out because the description about that there was anything at the time about the area being paved to make it usable for public access is so false. What the findings went on to say, quote, those members of the public who walk down to Sea Cliff State Beach will still be able to walk onto the beach at the end of the seawall without obstruction. The beach in front of the proposed seawall will still be accessible from Sea Cliff State Beach, and a minimum of usable beach space will be affected. Because of these factors, the project therefore would be consistent with the access policies of Chapter 3 of the Coastal Act. Nothing in the findings said because we're preserving, requiring, imposing public access across the areas that had been used as private decks for decades before the storm. It's just not in there. So on that issue of public access, I could stop now. It's not in the permit. It's not in the findings. Oh, but at the hearing, and you just saw a reference, there was a comment made by staff at the hearing, taken out of context. Well, I thought, well, what did the regional executive director say at the time? The fellow who actually signed the 1980 CDP. The easement area is identified on the parcel map as the 37-foot walkway area. Okay, so he's looking at this map. There's a paper easement. There's a reference to it. It has never actually been developed in that manner. This is the history of, in 1980, both staff and the regional director saying this was never used as a public boardwalk. The owners didn't agree to convert it to a public boardwalk. That language is not in the 1980 CDP, and the staff's findings at the time make clear why not. Plenty of public access up coast and down coast of these homes, period. Oh, okay, so it's not in the permit, it's not in the findings. The executive director made clear what he was talking about at the hearing. Let's look at a picture, and they put up two pictures. One was less than a second. I'm going to move on from this. This picture is what they showed you this picture down coast, saying there was no fence down coast. It was built in 1982, and we chuckled when they showed, oh look, it's here in the concrete, 1982. And look at this photo. Well, wait a minute. What was that? Oh, there's an obstruction higher than the brick wall down at this photo, which is admittedly a poor angle if what you're trying to do is show what was or wasn't there. But you can see, looks like a wooden fence. Looks like a lot like the fence that was there in the 50s. This is a photo before the brick exterior was added to 300 Beach Drive. This is a photo before 276 and 278 were even built. So we know it's before 1964. Fence built for the first time in 1982. False. Oh, now here's a photo we know was before St. Patrick's Day, 1963, because that's when the hotel on the hill burnt down. Undisputed. Again, we submitted newspaper articles of that fire during the trial. And what's that we see down below? The fence. The fence at 300 Beach Drive. Clear as clear can be. The identical footprint for the fence that's there years, decades later. Here's another angle. big fence, obvious. Does it matter? Oh, but look, and then the staff argues that this photo shows that the green fence was built on top of. Well, you can see the concrete going around the post there. So it wasn't just put on top. You can see the concrete was poured around the support beam for that fence that had been there for many, many decades. When you look at the close-up of this 1982 photo, was that topper on top of the concrete? You can see two different types of concrete. Was this concrete that was added when the actual county fence was? You can see the lip added by the county. Sorry. This permit is not in the materials that staff submitted. This is the permit to the county to rebuild. This same storm that damaged my client's patios took out a lot of Beach Drive. And so the county also applied for a CDP. And they got a permit that for the downcoast area that allowed for this lip and rail. And there it is. And the remarkable thing about this is you can see that it goes all the way across to the public sidewalk. So if this was part of this 2-mile public boardwalk, well, that would have been a good time for the county to repave it, wouldn't it? Instead of putting up a barrier pursuant to their own CDP. I'll say it again. We're looking at a photo. This terminates the sidewalk. It puts the lie to staff's argument that this was an acknowledged 2-mile public boardwalk, and only recently it's been blocked. That is not true. It's counterfactual. It's false. Did the county not notice the big green fence when they put in their, you know, the homeowners got their permit, completed their construction before the county? It's obvious. There it is, all the downcoast sidewalk, 4-foot wide sidewalk and railing. And when was it completed? Well, there's a notice of completion, 1982, for the county's rebuild. And they rebuilt the sidewalk and much of Beach Drive. And the argument you heard, oh, but they said when they got their permit to rebuild their patios and put in the revetment, that it would, a secondary purpose, not the primary purpose, a secondary purpose of the revetment would be to protect public works, I forget the word, but public material. Well, what was the actual public construction that the seawall for the HOA in 1980 was protecting? Well, the Beach Drive had been destroyed in the 1979-1980 storms. So by putting a revetment in front of those homes, you're protecting both the landward sidewalk and Beach Drive. The notion that that secondary purpose establishes that there was a 2-mile public boardwalk is just contrary to what we know to be true and what the evidence tells us. What's interesting, though, about the CDP to the county for their seawall, for their actual public sidewalk, is that there was a condition. And when there's a condition regarding public access, those words, public access, appear in the condition. So if you compare this language to the 1980 CDP to the HOA, you will not find the words public access in any condition. It's a serious thing when staff comes in, as they have, and said that a superior court who handled this matter for 4 years had a trial with actual witnesses, actual due process, actual evidence, briefing on numerous legal issues, witnesses for 7 days, issued a preliminary statement decision, a final statement decision. Staff comes in here and says, oh, he made factual errors. You can disregard that. Enforcement actually says, staff actually says at page, I think it's 61, that what went to trial was not any sort of county action at all. Now, in order for that statement to be true, you'd have to have a footnote that said, other than the unnoticed, unconstitutional demolition of a wall and taking a chainsaw to the fence, because absolutely action went to issue. The sixth cause of action was for an unconstitutional taking. What went to trial was not any sort of county action at all. It's just false. You can read the statement of decision if you can find it. It's not even in the index. We submitted it as part of our submission, but there's an actual record you can actually read. And as to the sixth cause of action for taking private property, the court finds in favor of plaintiffs. That's why the county has agreed, in lieu of a trial on damages, to pay millions of dollars, because it was an unconstitutional taking. Private property does matter. These are just some statements from the actual statement of decision. The heading, of course, not any sort of county action at all. I added the question mark because it's such an untrue statement. What the evidence did confirm is that the walk has been used as private property from 1929 to 2018, when the county exercised self-help as described below. On December 18th, only 4 days after the December 14th letter from Coastal Commission, that's the letter that was sent by staff to old Barbara Nelson at 202 Beach Drive saying, you must remove all your wall and all of your impediments by January 31st, 2019. This is 4 days, and the county and coastal staff, as you've heard, had been cooperating for years. And there's another story on that went to trial. But suffice it to say, the judge was concerned when he heard evidence that just 4 days before the demolition, Coastal Commission staff was sending Barbara Nelson, who had written and said, I've had a stroke. My husband's a disabled Army veteran. My attorney sent photos of the wall existing back to the 40s, and I'm sure a permit had been issued. She was right. The county had no desire to maintain this property, according to the judge, after 7 days of trial testimony, and took active steps to distance itself from any responsibility for the 37-foot walk over the span of over almost 90 years. At some point, the actual chronology of events that led to this trial must take priority. So county action did go to trial. So staff is wrong when they try to tell you there was not any sort of county action. They were aware of it. They knew about it. They showed up. They showed up for the demolitions. Pat Viesart was there to give an interview to the media. As the judge said, no advance notice of these actions was submitted to any homeowner nor to their counsel. However, notice was provided to media who recorded the event. Now you have to keep in mind that the wall and the fence were demolished after the homeowners went to court on the issue of who owns this property. Is there an easement? They didn't resort to self-help. They went to court, they asked for a decision, and in response to that, the county, after meeting with Coastal Commission staff, came up with this plan to demolish the wall and the fence. That's disturbing. But Deputy Director Dan Carl thought that could be good to knock down the wall and fence. Seems like a good PR push around knocking down the wall and fence could be both really dramatic and really helpful. This is a staff report that was submitted a couple weeks ago, page 61, describing our statement of defense. Now, normally I like to present my own defense because sometimes the other side doesn't always get it right, as has happened here. We see staff saying still, on page 2 of the statement of defense, it states, quote, the county's enforcement role in this matter proceeded to a trial on the merits, and the court determined that the county and public had no interest in the walk and emphasized due process violations highlighted herein. That's true. That did happen. It's in our statement of defense. I'm 110% correct on that statement. And yet staff says, once again, this is false for multiple reasons. Now, this body has a choice. You can either just accept staff's slapdash presentation and these types of false statements, or you can look at the evidence. You could put this over. You could deny it. I mean, what's happening here at 5:10 on December 14th is not right. Because what this is, again, I'm comparing the description from staff to what the court actually said. The suggestion by the county that the public possesses some type of interest in the property is contradicted by the evidence confirming that for 79 years, 1929 to 2018, the area was maintained and utilized by private homeowners. That's what the statement of decision said. That's what we said it said. We were not wrong. The judge went on in his statement of decision, soon to be a judgment. The county conceded that there was no transfer of interest, the subject property resulting from the 1980 encroachment permit. Encroachment permit didn't create or require transfer of any interest. And the judge, getting to the point of why we're here, writing encroachment in the 1980 permit does not override 50 years of disinterest, let alone overt attempts to relinquish any alleged rights. Stating in a permit that an easement is preserved does not create nor confirm such an easement. Well, just because the county was wrong, your staff's making the same argument here. Another contention, the existing barriers are actually in place pursuant to a court order. Yet staff says at page 5 and 36, the HOA members have actively sought to block public access to the walkway and have erected makeshift barriers in violation of the 1980 CDP condition number 1. We've already seen that that condition number 1 does not include any such requirement. It does matter, though, that there was an actual trial, not just a statement of final decision, but an actual order on preliminary injunction, which is now permanent, allowing those barriers to be erected. Why? Because the county was wrong to remove them. The fencing may be placed immediately and shall remain in place pending entry of judgment or further order of the court. The idea that millions of dollars of penalties should be levied against the citizens of this state for following a court order. Oh, the judge didn't mandate they do it. No, he allowed them to repair what the county took unconstitutionally. It would be unprecedented. This commission has never awarded penalties against someone for following a court order. So for staff to come in and say that the judge got it wrong, that there are factual errors, I'd like to take a few minutes and just review some of that evidence submitted in an actual trial. Began with the same map that staff has told you created the 37-foot wide walk in 1928. Staff actually said there was a public dedication. That's false. There was an offer. It was not accepted. The Board of Supervisors of the County of Santa Cruz approves this map, but does not accept any of the streets shown thereon. In 2004, as a result of the commission coming back and saying, hey, we think there should be public access, the homeowners and the president of the homeowner association, Dr. Schlichting, went back to the county and said, hey, they're saying that that you have an easement. So the county assessor, longtime assessor Hazelton, also the county recorder, reviewed the matter, and he sent a formal letter to the HOA in 2004. This letter is to confirm our discussion concerning the property described as a 37-foot walk. Goes on, as we discussed, it is my position that we would not reappraise any of the properties if what? If the 37-foot walk is incorporated into the existing parcels. I believe that over the years, since 1928, there has been an implied ownership of the walk by the homeowners along Beach Drive. Golly, if there had been a 2-mile public boardwalk, which is the first sentence of staff's report, you don't think the assessor would know that? The only change that would occur is if the properties are combined, a new parcel number will be assigned to each of the parcels. This is what the judge is ordering occur now. The assessor in 2004 was right. It matters. Your staff is misleading you. They're just wrong. They don't cite or discuss this letter. So just to briefly summarize, why do I say the homeowner's rights to the patios vested by 1960? Because the first homes, as they're built in 1935, that area was already fenced. The photo the staff showed you, somewhat misleading, there were no buildings erected and there was no fence in place when they showed cars at some earlier point in time. But by 1935, there are homes being built. By 1947, County Road Commissioner says, hey, we have this road on paper. It's an unimproved secondary road. There it is. It's not listed as a public boardwalk. Unimproved road. Of course, there was no access. We've seen up coast and down coast historic photos that matter. And then in 1953, the same road commissioner tells the Board of Supervisors, and you're looking at official county records, Board of Supervisor minutes. Road commissioner says we should abandon this 37-foot walk listed as a road on my inventory. County never spent a penny on it. 1955, a new law was adopted that I didn't hear discussed. What's the new law? The new law exactly applies to this circumstance where you have an offer of public dedication on the map, it's not accepted on the map, and then it's used as private property. After 25 years, it vests as private property. Conclusive presumption. So by 1960, there was no easement. There was no ever any public boardwalk, as staff would have you believe. 1958, the County Board of Supervisors said, geez, we're not using it. Let's sell it to the homeowners. Then they realized, well, we don't even have title. And again, there were official minutes. In a quiet title action, where the only other party says we don't have title, that's pretty dispositive. And the homeowners weren't required to do anything. The law is clear in California under the Paris case. Their rights vested as soon as that 25-year period expired. In 1963, so that there'd be no doubt, there was a recorded revocation of all the offers of public dedication on that 1928 map. Again, we're blowing through evidence that was presented over a period of many days through many witnesses in an actual trial, but I think it matters. Revocation. Oh, and the county relied on that in a lawsuit in 1966 for another, what appeared to be a public trail in the same map, saying, nope, wasn't used for 25 years. It's private. 1968, the county went and looked, and they noticed, this is from the right-of-way folks, that even at that time, 1968, for many, many years, homeowners had used the area without any protest or complaint from the county. This is the county noting this in 1968. And what I noted in this document, another document from trial exhibit 21, the county's right-of-way expert noted that the area had been used as a patio and there are numerous improvements and obstructions within the walkway area. That's what we've heard staff tell you today, such as furnishings, fencing, walls, etc. The difference is staff told you this happened after 1982. There was a wall and fence well before 1968. The county recognized back in 1968, not only had the homeowners been allowed to use those patios without protest, there is a distinct possibility that legal action may have to be taken to force the removal of existing private improvements within the area. But there's more. There's an actual board resolution from 1973. The 12-foot public walk that you've heard about today and that they're all gung-ho to impose across private property, been deemed private in a quiet title action. Oh, here's a resolution from 1973. There was a state parks project where the county was going to transfer any rights that they had in the 37-foot walkway, and there was going to be a 12-foot public walkway. Where was it going to be? Seaward of the existing 37-foot walkway adjacent to the island homes at an elevation no higher than what? The existing patio areas. Document after document after document, no reference to 2-mile public boardwalk. That's a fiction. That's a description. It's not borne out. Just very briefly, the county wanted to transfer whatever rights they had to the state. The state wrote them and said, hold on, you can't even transfer the 37-foot walk. There's very complicated title problems. The state publicly announced, state parks, if they needed to go into the 37-foot walk, they might need an encroachment permit from the homeowners. In February 1974, the state provided a title report to the county showing the county lacked title to transfer any portion of the 37-foot walk. So what did the county do? Did they say, well, wait a minute, we have this public boardwalk? No, they went to the homeowners and said, we need a quitclaim deed. Now, do you ask for a quitclaim deed from every homeowner for property that you already own and have used as a public boardwalk? The homeowners said, no, thank you. We'll keep it private. We'll keep it as our private patios. And then there was the storm. And the storm's damaged. You can actually see in this photo, though, those partitions between the patios and the part that wasn't destroyed. Then there's the 1981. The 1980 permit is issued. Any reference to a public boardwalk? Construction of a, I'm reading from the permit, construction of a 787-foot long riprap seawall on beach in front of homes on Beach Drive. Replace 8 feet of concrete patio at the rear of each home. Well, that would have been a good place if what staff told you was true, to say replace public boardwalk. Commission staff understood 1980, what was going on. Homeowners were replaced. And oh, wait a minute, was it the county applying for a coastal development permit to replace a destroyed public boardwalk? No, they did that down coast to replace the road and the actual public sidewalk. The wall would abut each residence's concrete deck. Permit goes on, numerous references. Existing 12 feet concrete deck to remain, existing 8 feet damaged or destroyed concrete deck to be replaced. Nothing about paved for public use. This diagram simply shows that part of those decks adjacent to each home. They wouldn't have been described that way. They wouldn't have been expressly referred to as used as private patios. Now, the state parks took a look at this in 1981 and actually sent a letter to the Coastal Commission saying, we have a survey, we looked at it, and the seawall is going to be entirely on the permittee's property. Nothing about it being on any sort of public boardwalk. So the Coastal Commission actually had that survey from the state in 1981. So let's talk about the permitted staircase at 264 Beach Drive. This homeowner, to replace an old metal staircase jutting out about 11 feet into the patio, this fictional public boardwalk, got a permit. And the county actually said in order to meet the new rise and run requirements, it needs to go farther into your patio area. There's the permit. You got a permit in 2013. The county inspected it 4 times. Over and over, and they gave her this permit. When the Coastal Commission wrote her a letter saying your staircase is unpermitted and must be removed, she contacted Pat Visart. She wrote to him. These are serious people. They took this seriously. They reached out to the enforcement fellow who sent this letter to every single homeowner. She writes back, "Hi, Pat. Wanted to keep you up to speed on my efforts. I talked to county council this week about our stairs, sent them a copy of the permit documentation. I'm also attaching the same documents below for your records, Pat." He wrote back. He didn't say, "We reject this. You don't have a coastal development permit." He confirms that this is a county issue. Thank you. Yes, work with the county. And what did she send him? She sent him the actual county record that properly noted that the staircase was exempt because it was a replacement in kind. Those were the old stairs. So that's why I had 2 conference calls, Mr. Erskine and I, with your enforcement staff in June. And I said, I welcome a merits-based discussion. I'm happy to discuss any of these issues with you. We'd like an extension. No extension unless you agree to public access immediately. I said, well, there are other issues I'm sure we can resolve. And I said, well, let me ask you about the staircase at 264. Totally unfair for you to ask me about that. This is after the May 12th notice of intent to seek a cease and desist. I actually don't know as I stand here today whether their position is, despite the county permit office saying it's exempt from a CDP, and despite the email from enforcement staff saying go talk to the county, whether the HOA is supposed to tell this owner, remove your lawful permitted staircase that you got 10 years ago. Let's talk for a minute about the concrete stairs. HOA built unpermitted and crooked concrete stairway into the revetment. This is page 44. The CDP only allowed for rock stairway in straight line. The 1981 CDP minor amendment allowing those stairs for the homeowners to access the beach only states rock stairway to Rio Del Mar State Beach. Neither the 1980 CDP nor the hearing transcript provide any reference to stairs on the revetment. The only requirement is in the plot plan that council briefly showed you, the stairs for the steps 3 feet wide. There they are. There's nothing about straight or crooked. They're reading into a permit words that do not exist. So just to recap, there was an actual unbiased judge who sat and heard actual witnesses describe actual evidence and actual events. That was in April. He heard that testimony. This is probably the most experienced judge, presiding judge in Santa Cruz County. Been a judge for many years. He considered hundreds of documents, numerous legal briefs. He issued a final statement of decision. He rejected the county's cross complaint. The county had sued the homeowners, saying they had title. He rejected the cross complaint, making the same argument that staff puts in their report, that these homeowners are profiting from the use of public property. It's not true. And he found that the county took private property without compensation, a due process violation. And again, I would urge each of you to read the judge's well-reasoned, detailed, accurate 16-page statement of decision, soon to be part of a final judgment. We've seen some of this, I won't belabor it. The suggestion by the county that the public possesses some type of interest in the property. And I'm just going to stop here because the county did work with the Coastal Commission, did call a witness, Ryan Maroney, to testify, was going to call Pat Visart to trial after Mr. Maroney's devastating testimony, decided not to call him. The judge did look at the 1980 CDP because county put forward the same argument that Coastal Commission is putting forward, that this document, surely, Your Honor, this encroachment permit and this 1980 CDP created rights in the public. And he rejected that based on the evidence. Writing encroachment does not override 50 years of disinterest. So, just briefly, The judge noted that the facts of the seawall permit process were under such intense public government review, neither the county nor the Coastal Commission even voiced a concern over the presence of the gate and/or wall at each end of the walkway that were there in 1980 and probably for several decades before, and failing to demand removal of those structures support a finding in favor of the plaintiffs. And yet staff comes before you, as they did today, and it's in their report at page 10, even if no public easement ever existed. Now, my goodness, if this is all you had, and I know it's late in the day, and I appreciate your indulgence, but this matters. These are real people, it's real lives. Quote, even if no public easement ever existed over the walkway, this would not change the CDP requirement that the HOA preserve public access to the walkway. So even if no walkway, you have to preserve public access to the non-existent walkway. I'll say that again. Staff is saying, even if no public easement ever existed over the walkway, well then there was no walkway. You can't say there's a walkway that the public owns. People own property rights. And I see maybe there's a question based on the look on some of the commissioners' faces. The public doesn't own anything here. The county came in and said, we own it. We have an easement, or maybe we have a fee interest, we're not sure. But it was the county that said they owned it on behalf of the public. So without the easement, there is no public interest. That's why the judge said this is private property. Complete. Private property fundamentally means you have the right to exclude others. I have a front yard. It's not fenced. Does that mean the public can walk on it and claim it's theirs? No. It's private property. That's what the judge said. And before staff comes in and says it doesn't matter if a walkway ever existed, an easement ever existed, you better take another look at the Bay Island Club case where there was a prior quiet title action. There, the California Court of Appeal said the commission conditioned a bridge's CDP on right of public access across the bridge because CCC believed the public had an existing right to access the bridge. However, that was contrary to findings of an earlier quiet title action. When a judgment is clear, we have no authority to read it any way other than as written. That case addressing this same legal issue should be binding on the commission here. You can't just disregard an actual judicial proceeding for whatever interpretation after the fact. Okay, I won't belabor this. This notion that, oh, there's been no, we could ask the county, this is the delegation issue in this case. There's a number of legal issues. I think the primary factual issue here is the 1980 CDP does not include an express condition of public access, and you can't get there by looking at the findings. But the county and the commission tried to create a paper trail that, oh, the county, you're not doing anything, so we'll take it from here. Mr. Modelbog wrote to Deputy County Counsel Shaw in January of this year. The Coastal Commission may issue a cease and desist order for violations of a local coastal plan if the county requests that the commission assist with or assume primary responsibility for issuing such an order. The commission may also issue such an order if the county does not act. Now, and then no response. Mr. Modelbog follows up in February. And then in March, county writes back, the County of Santa Cruz does not intend to pursue alleged violations of the Coastal Act relative to the 37-foot walk area. Well, this will not withstand judicial scrutiny. They already took actions. When? When they demolished the wall, when they took a chainsaw to the fence. That was unconstitutional. They have to pay for it. So they did take action. So the commission can't come in now and say, can you pretend that you didn't take action? And they're still taking action. They're appealing that judge's ruling on the preliminary injunction. So those are the facts. If I could just have another 10 minutes, I should be able to finish
I'm
up.
sorry, sir. In fact, I really appreciate it. Thank you very much.
So just
for
so we're
the
clear,
time that you
I don't
took.
want to be accused of waiving any rights. If you cut me off, Madam Chair,
Mhm.
that is a due process violation. I'm entitled to meet this evidence. You can shake your head.
Well, here at
I'm
the
sorry.
Coastal Commission, the chair sets the time. In this case, you've received an equal amount of time that staff, actually additional amount
So
of time.
I'm asking just for 10 minutes and the answer is no.
That's correct.
Okay. thank
So
you.
what I'm going to do at this time is I'm going to take a break so that people can deal with the things people need to deal with. Let's try and come back as quickly as possible, but definitely no longer than 10 minutes. And please do not discuss the case or any of the testimony so far. It's 5:34. I'll see you at 6:35. $44. All right. We're back from our short break. Thank you very much. We've heard the presentation of the alleged violator. We're now going to return to staff, keeping in mind that staff still has remaining 9 minutes of the original 55 minutes. They'll be utilizing that for rebuttal. All right, so I'm back to staff.
Okay, Commissioners, thank you very much, and I'm sorry for the lateness of the hour. I'm going to just blast through things as fast as I can because there were very, very many odd and inaccurate statements. I would say just, and I'm going to try to take them in rough order as I heard them, but one of the first things he said was that staff objected to the supplemental statement of defense. It is true, and we addressed that in the addendum, that there's no legal right to submit that. But we did. We put it in the addendum as part of the record, and we made it available to commissioners and the public. So that is, and responded to it. And that's typical of the kind of objections that he raised. They were things that we have asked and answered over and over and over and over. Another example is he quoted at length the quotes from the decision from the court. I understand they're very pleased that they were able to beat the county and prevail in that litigation. It's just irrelevant. All of the discussion about who owns the walkway is not relevant. We don't care who owns the walkway. The commission routinely places easements and requires public access to both public and privately held property. It just doesn't matter who owns the walkway. We understand that it meant a lot to them and they really wanted to litigate against the county, and they did win at the trial court. I would also note that that's not a final decision and it may be appealed, but in any event, it's just not relevant to what's before us today. And I'm a little baffled by the amount of time that they spent on those various points because, and I'm going to go through a couple of the specifics. He says, for example, that we said even if no public easement ever existed over the walkway, this would not change the CDP requirement that the HOA preserve public access to the walkway. And he paused very dramatically on that slide for some amount of time. And this is just another iteration of the same the same point, which is that ownership issues are not relevant here. What we were saying is that the commission was enforcing its CDP requirement that the commission put in place. And he also there's a long discussion about whether or not we really incorporated by reference the local easement requirement and whether or not that would fail if the easement itself proved not to be held. It just doesn't matter. What the commission was using is the location of the county easement, and you saw the very clear, we don't have time to put it up, but we had a very clear graphic from the original staff report showing what the commission understood the area of the walkway to be. That was what they were incorporating. It happened to be called the easement because everybody, including the HOA, agreed at that time that it was an easement held by the county. But it was just a way of identifying the area to which the commission wanted to place an access requirement. And now I want to really just quickly, because one of the issues that they raised was this wall at 202, and our staff geologist, engineer is going to address that.
Hi, Commissioners, and Jeremy Smith for the record, because I don't have my my nameplate here. But Thanks, Lisa. So my interpretation of the plans that are reviewed, the building permit plans, are that a new wall on the seaward side of the property at 202 was constructed as part of the county building permit. Above the project description line, this is even referred to as a retaining wall. Regardless of whether a wall may have existed before, the footings could not have easily been replaced and structurally tied in without having to reconstruct the wall on top of them. There is nothing on the plans that suggests only footings were replaced, such as a shoring plan. So, to be clear, the plans show the construction of a new wall in addition to footings and anchors into the patio. Thank you.
And I'm sorry to just rush from one topic to another, but this is like a game show. So if you, one of the other issues that he discussed at some length was 264. And 264 is reference to a specific property held by somebody called Paula Pyers. And he kept asking about how this could possibly be a violation when the county gave her an exemption. There's no, first of all, as a threshold issue, there is no penalty or order directed towards Paula Pyers in this action. There is none. It's just not relevant. But also, the county got it wrong. It wasn't exempt. And we have many cases, and we've litigated some where the county inappropriately or in error thinks something's exempt and it's not. And that doesn't preclude the Coastal Commission from coming in and taking an action. We understand that she might have thought that it was exempt, but as a result, we're not proposing any penalty for her or for those stairs. We are, however, telling the HOA that they need to be removed as they're both illegal and obstructing the walkway. And the penalty to the HOA is for blocking off the walkway, not for these stairs in specific. And also, she can apply for a CDP for this as long as it doesn't preclude public access. I don't want to spend a huge amount of time, but that staircase comes down and has one dog leg. It could have another one. It could be a spiral. It could be anything. We're happy to work with her. And at one point, the county even offered to fund a different staircase after they found out that they'd issued the exemption in error. So that's all I'm going to say about 264. And Alex is going to address some of the other legal issues quickly.
I think I'm just going to address 2 points, given the amount of time left. One is that Mr. Richards spent quite a bit of time on page 61 of the staff report indicating that staff was saying something inaccurate. If you look at the bottom of page 61 of the staff report, where he was quoting it, where he said that we said that what went to trial was not any kind of county action at all, that's taken out of context. What it says in that paragraph we were responding to is a statement in the statement of defense that said that what went, the county enforcement role in this matter proceeded to trial. And what we were saying was it wasn't a county enforcement matter that proceeded to trial because the county wasn't enforcing the Coastal Act. The county was acting under its proprietary interest as it understood it to be in ownership of that walkway. So when we said it wasn't a county action that went to trial, maybe it was a little bit inelegant. We should have said it wasn't a county enforcement action that went to trial. Yes, it was a county physical action. But if you look at it in context, that's clear. Staff wasn't saying anything inaccurate. And the other part of it that at the end of that section of the staff report, he's quoting, it says, oh, right, that the due process issues, that the court had determined that the due process issues addressed herein were violations. Well, addressed herein is a reference to that statement of defense where he accuses the commission of due process violations. And why we said that wasn't true is, as explained in the addendum, because the court was obviously not addressing due process violations by the commission. The commission hadn't acted yet. So you take these things out of context, they can be confusing, but if you look at them in context, that's the explanation. I think I'll just address one other thing. In terms of the openings at both ends, you know, both of us are making some inferences. Neither of us were there in 1980. We believe the evidence shows that the walkway was open at both ends, but at the end of the day, the debates about fences at the two ends are really ancillary. They only arose as a response to the HOA's argument that if the commission intended to require access, it would have required the removal of fences. And that's why we went and looked and saw, well, actually, it looks like they were open. And maybe that's why the commission didn't require the removal of fences. But there are lots of other explanations for why the commission wouldn't have bothered to do that. The most obvious explanation is simply that it wasn't necessary. The commission was incorporating a requirement of the county to turn this into a walkway. So the commission was relying on the county to take whatever steps would have been necessary to make that walkway available. The fundamental issue here, really, though, is just what the 1980 CDP required. And we acknowledge that some of these early permits are not models of clarity. The commission has learned a lot in 43 years about how to make its conditions more clear, but that doesn't mean that we should just abandon them or abandon any effort to understand what was intended or to enforce it. A plain reading of the condition does require that the access be provided here because it incorporates by reference the county's requirement. And again, he says, you know, there's nothing in the permit that says it, but incorporation by reference is a standard legal process. And once you've incorporated by something by reference, then it is in the thing in which you've incorporated it into. So it is in the permit, even if it's not explicitly written. That's what incorporation by reference means. And so, yes, it requires you to understand that concept, but that's not rocket science. The bottom line is, if the commission believes that the permit language leaves any question as to the 1980 commission's intent, then we would simply direct you to all of the contemporaneous evidence, including the staff presentation, where Linda Lockman, who's here today, gave the presentation and said, this is okay because there is going to be access here. The bylaws adopted by the HOA after the permit was approved, the 1981 letter by Mr. Van Lukes, who was the main speaker as on behalf of the applicant at the 1980 hearing, acknowledging the permit's requirement, the permit required access to the walk, all of which demonstrate that the understanding of all the parties involved at the time was that this permit would result in public access. Okay,
I got 9 seconds. That fence, it fell into the ocean in 1980 along with the walkway. The 8 feet of walkway, it stands to reason 8 feet of fence also fell into the ocean. Thanks.
Okay. That was good, except it could have been more musical, but it was good. Okay. All right, folks, we've heard 2 hours now of staff presentation. The alleged violator has had 55 minutes for their presentation. Now going to open up public comment on this. I understand we have some people that have signed up for public comment.
Yes,
I'm
we
going to
have,
give you 2 minutes each. So,
we have a number of folks in person, starting with Susan Jordan, Mike Guth, and Barry Scott. I can read all the names just so that people are.
sure,
aware.
why don't you do
Okay.
that? And then perhaps everyone could get ready to come up and we could expedite this process. So please, go ahead.
Additionally, we have Kate St. Clair, Tina Andriotta, Mariah Roberts, Yadira Flores, and Laura Walsh.
All right, Ms. Jordan, are you here? Not here. Not here. She had to shut down. Okay, next.
Mike Guth.
All
Or
right, Mr.
Guth.
Duff. And then could the next speaker be prepared to just walk up to follow Mr. Duff?
It would
Who's
be
after him?
Barry Scott and Kate St.
Okay,
Clair.
if you could be ready, that would be great.
Am I able to get 3 minutes as a
It'll be 2
representative of a
minutes
group?
per speaker.
Okay. Hello, Chair Hart and Commissioners. My name is Mike Guth. I'm here speaking on behalf of the Sierra Club with its over 500,000 members in the state of California. Sierra Club supports the staff recommendation in this case, specifically to reopen the public walkway, which is going to include removing unpermitted structures at each end of the walkway, to also remove the refuse bin at each refuse bins on the sidewalk on the other side, and to restore the native dune habitat over the revetment. And this is a 40-year overdue condition. No, it's not something that was spoken to by the fence side here. It seems like it's an inexcusable delay. There's extensive discussion in the staff report, which as an attorney myself, I took great interest in reading. I'm not going to rehash what is said, but I don't understand how your commission council had the patience to address, readdress, and readdress again all of the things that they've addressed over the course of the last few years. And although I sit on the California State Sierra Club's Coastal Subcommittee, I didn't parachute in here. Can't see it now. I was going to point out where I live. I live on the next point up there. I've been surfing there since the 70s. I've lived there since the 80s, and I've been a homeowner there since the 90s. I've got decades of coastal conservation, resource conservation experience in this county, including being a longtime county planning commissioner for District 1, which starts down there. And in my experience, most of the residents embrace Coastal Act. They understand for the greater good, there are certain impositions that we take. There's always been a small subset, and still is, a small subset of folks that don't. And all you need to do is look at the pictures we put on our letter on page 33 of your addendum, but I'll just describe them for you. To look at the blockages on the walkway on the front, which route people to the sidewalk, and see that those same people 7 days a week block the sidewalk with that speaks volumes about what kind of circumstance we're dealing with here. And I see my time is short. Please adopt the staff recommendation. Thank you.
Thank you, Mr. Duff.
Barry Scott, Kate St. Clair.
Mr. Stott. And next will be Kate Sinclair. Are you here? Doesn't look like it. Who's the next person? Are you Ms. Sinclair? I'll give you 3 minutes if you want to cede your time. You could have 3 minutes in that case.
Okay, I have slides and I hope you can find those.
Do you have those?
There are 8 slides.
Opening them now.
All right. Be 3 minutes on the clock.
My name is Barry Scott. I live immediately adjacent to the beach island, and I'm a member of the board of the Rio Del Mar Improvement Association. I've lived in a 1-bedroom condo exclusively, my home, for 10 years now. And I've been using the walkway for years and years, for longer than that. It's always been open on at the 202 location and been closed at the opposite end. And I've enjoyed that. The public has enjoyed that. The first slide shows you what it looks like right now. I mean, what it looked like up until they closed it. So that we had like 3 years of a beautiful open walkway. What is that? 4 years, 3 years. Next slide, please. That's what it looks like now. Next slide. At the and as you've seen in all the other slides. Next slide, please. I went down one week in May and I counted 7 days in a row, 46 cans, blocking a 36-inch sidewalk, taking up most of the space just like that. And cars parked. There's no passage even for a single human being, never mind a carriage or anything else. And even if the cans were gone, it's not wide enough. So that's pathetic. Next slide, please. This is, I hope you can see it. The island is about 800 feet long, but the entire 3,000 feet more of Beach Drive is closed at the opposite end. So this closure caused by these owners restricts us, prevents us from accessing all of Rio Del Mar Beach, another 3,000 feet beyond the closure. And that needs to be taken into account. It's not just access to that little bit of beach by the patio. Next slide. Owners have been enjoying about roughly 40%. I'm going to say 8 feet to them with their little walls and I don't mind that. Speaking as a user of the walkway, with 12 feet left over roughly for out of a full 20 feet that's available. And if they would just open up access again, I would be happy. Next slide. And again, that's the final slide. That's what it looked like before. That's what it needs to look like again. All of these stairs and things that you see kind of outside of the surface, the plane of the building itself is in the public area. But they've been enjoying it, and maybe a nice compromise is to let them have that if they will immediately remove those barriers. And I support the Coastal Commission wholeheartedly in all of your staff recommendations. The only other statement I had that one of my 2 friends was going to read, but they're afraid, was a statement from 22 parents that wrote a letter.
Okay, why don't you read that?
Thank you very much. It's I thank you for that, and it's the Fit for Mom Santa Cruz organization, and in just 24 hours, 22 moms representing with collectively 38 kids that like to use that walkway wrote this letter. We, as long-term local residents and community members of Santa Cruz County, believe that restoring public access to the pedestrian path located seaward of the Rio Del Mar Beach Island HOA is essential to providing a safe route for families with young children and persons with disabilities. The narrow, uneven sidewalk on the opposite side of the homes, with multiple curb cuts, trash cans, and outward swinging front doors blocking the walkway, is not passable for persons using strollers, walking, or jogging with young children, or other persons utilizing wheeled mobility devices, never mind senior citizens and the disabled. There is hardly room for one stroller to navigate this uneven terrain, forcing someone off steep curb onto incoming traffic in the street when met with another pedestrian traveling the opposite direction. We, as community of Fit for Mom Santa Cruz, have not been able to utilize beaches for our free family meetups and community exercise classes as a direct result of this walkway closure and the lack of pedestrian safety that it has caused. Publicly owned beachside walkway provides a safe space for our families to pass through to access the coast. Therefore, as active moms striving to maintain our own wellness while raising the next generation with a love of nature, health, and community, we urge the Coastal Commission to return this space to the families of Santa Cruz County. Thank you for allowing our voice to be heard on this matter. Thank you.
Thank you. I appreciate it. All right, who is left, Bill?
Tina Andriotta, Mariah Roberts, Yadira Flores, and Laura Walsh.
All right, so who of that group, if you're here, come on up and please be ready to go immediately after the person in front of you. So the next speaker is
Tina Andriotta.
Andriotta. Are you here? Okay, you're not speaking. All right.
Mariah
next.
Roberts.
Mariah? Mariah Roberts?
Correct.
Thank you.
And I submitted a video earlier. So before we start. my
And you'll have 2 minutes.
So beautiful. Coastal access, you guys.
Thank you so much. We submitted that. Mariah Roberts, Executive Director of County Park Friends. We're the nonprofit partner to our county park system, and we work every day really hard to increase access and open access. So to be here and hear people trying to do the opposite is incredibly disheartening, and we're incredibly grateful to you all. We commend you. We commend your recommendation enforcements against those blocking access at Beach Island. Besides dragging our local government through an unnecessary and costly court process, these property owners have closed the only wheelchair access along this public beach, as you just saw. It's been maddening and disheartening. I want to just call out our colleague Brenda Gutierrez Baeza, who is a commissioner on disabilities for our county, who you saw featured in that video. She tours all of our public spaces and she does assessments. Are they accessible? Are they places that she wants to recommend for her community? And we shot that video. She had already planned to go and review this space and promote it. And we shot the video and found out that morning that it was about to be closed down. And you've seen how it's been ever since. So thank you so much for taking this up on behalf of our community and for those who couldn't be here today.
Thank you so much, and please thank her for that video. Really
We will
appreciate
do.
it.
That's
All right, next speaker.
Yadira Flores.
Hello, Ms. Flores.
Hi, my name is Yadira Flores. Hi, my name is Yadira Flores. I am community mobilization leader with County Park Friends. My first time in this commission. I thank you all for your service and your patience. We've been here since 9 in the morning, thinking there is the second item. God, I have 4 kids at home waiting for me, so I'm gonna be fast. As in my role as a community mobilization leader, I engage local audiences and broader our communities outreach, especially to youth from racial and Asian diverse backgrounds that have been traditionally underserved. We, County Park Friends, offer transformative experiences that build deep connections to our public country parks and public land. Through my service, I engage local families, but especially youth from racial and ethnically diverse backgrounds that have been traditionally underserved. Saying that, the parking of Rio del Mar is the only parking lot that is offered as no charge for parking, which make it accessible for these particular communities. With that being said, now currently we don't have any mobi mat. I don't know if you're familiar with mobi mat. They're those that you put along the beach. So, okay, there is no mobi mats in all Santa Cruz County. So those coastal access are the closest shot that many members of the disability communities can get to see and enjoy our beautiful coast and ocean. And finally, this issue just highlight what is happening in a lot of not all, in a lot, if not all of the coastal access trails. We need to preserve and provide those coastal access with a big bilingual sign and welcoming for everyone. Thank you.
Thank
Thank
you
you.
so much.
Laura Walsh is our last speaker.
All right, Laura, 2 minutes.
Surfrider Foundation and California Coastal Protection Network support the staff recommendation.
That's the kind of public comment I was hoping for. All right, closing public comment at this time. No other further public speakers. Going to bring it back to the commission. Obviously, the commission in this action may ask questions of staff and as well as the attorneys for the alleged violator. So I will open it up to the commission and Commissioner Brownsy.
Thank you, Madam Chair. For myself and just at the appropriate moment, I'd be very honored to make the motions associated with this cease and desist order and the penalties. While I do think the penalties are a little light, given the intensity of the restriction of the violations, I'm going to defer to staff's judgment. I think they made every single finding that they were required to make under law in order to issue the cease and desist order, as well as their very conservative assessment of penalties for both the HOA and the owners of 202 Beach. It's sad, I think, that this particular area, which is very beautiful, beachfront, kind of looks like a crime scene now. And, it's just, hopefully after this action, there can be some resolution and collaboration among the parties so that the people of California can have access to this walkway, which is actually more important than the actual length of the walkway because of its connectivity and its necessity for those who are less abled. Madam Chair, with that, I'll just defer to when you'd like me to do it.
Okay, thank you very much, Commissioner Brownsy. I'm going to turn to Commissioner Aguirre, who has a question.
Just a quick question for staff. So when you reference the encroachment of the balconies, you said something about making an accommodation, but technically you could, I guess the right term would be, issue issue a notice of violation for that encroachment is what I'm wondering.
Yes, thank you, Commissioner Gary. In fact, one of the public commenters also mentioned about whether or not we could make an accommodation and talked about that first 8 feet in the orders. And we didn't highlight this because it wasn't one of the more contested points, but the orders only require removal of things beyond the first 8 feet. There are many violations within the first 8 feet, including posts that hold up patios and second stories. And we chose to recommend not to remove those because we wanted to get it open quickly and to get so then there would at least be the 12 feet that the public could use. But there are other violations that we were not requiring to be removed here, and that's what was an accommodation. It would greatly reduce the amount of cost for the homeowners to comply.
Of course, I understand that. I just wanted to understand a little bit more the rationale.
I mean, we haven't given them a release so that if they wanted to pile a bunch of stuff there that was a problem later, the commission could still come back and order it out, but we're just not ordering it out in this action.
In this particular action. I understand. Thank you. I agree that the penalty is a bit light. And, you are going for the 75%. I mean, if there's consensus and want to do 100, I would be open to that. Thank you very much.
All right. Seeing no other requests, no other questions, no other comments, I'm going to read. I'm sorry, there is one. Commissioner Cummings.
Thank you. Yes, this has been a big issue for this community for a long time. And we've had in the past other attempts at restricting public access. I think we all remember Privates, which was on Opal Cliffs, and there's been other instances when public access has been limited. And I do want to say that outside of the opening of the walkway and the walkway itself, there were other numerous violations that have been occurring here that I also feel like, need to be addressed. And there was no indication that they felt like they were innocent of those violations here. And so, I will also say that I do think that the penalties being imposed are a little light, given the fact that our staff tried to really engage and come up with an amicable solution here and not get us to this point. And so, I think it's definitely wasted a lot of, public dollars on staff time. And I do think that, I agree with my colleagues on the penalty being light in this instance, but I do, based on the information that's been provided, I do think the staff made a really good case in this instance for increasing public access and the violations that have been described in the agenda report.
Thank you so much, commissioners. I've heard you both. However, we're about to have a motion on the table. I think we should proceed with the motion. If there is a strong desire to amend that or change it, we can address it at the time. We have a number of motions here. We're going to begin with motion 1, Commissioner Brownsy, the cease and desist order. These motions, folks, are all starting on page 19.
Thank you, Madam Chair. I move that the commission issues cease and desist order number CCC-23-CD-05 to Rio Del Mar Beach Island Homeowners Association pursuant to the staff recommendation, and I'm looking for an aye vote.
I'll second.
All right. Motion is made by Brownsy, seconded by Cummings. May I have a roll call vote, please? Ms. Miller.
Commissioner Brownsy,
Aye.
Brownsy, yes. Commissioner Cummings,
Aye.
Cummings, yes. Commissioner Escalante,
Yes.
Escalante, yes. Commissioner Harmon,
Yes.
Harmon, yes. Commissioner Nuttall,
Aye.
Nuttall, yes. Commissioner Rice,
Yes.
Rice, yes. Commissioner Turnbull Sanders,
Yes.
Turnbull Sanders, yes. Commissioner Uranga,
Aye.
Uranga, yes. Commissioner Wilson,
Aye.
Wilson, yes. Commissioner Aguirre,
Yes.
Aguirre, yes. Commissioner Bochco,
Yes.
Bochco, yes. Chair Hart,
Yes.
Hart, yes. The vote is unanimous.
All right, that motion is adopted. The resolution is adopted. We are now moving to motion 2, administrative civil penalty action under section 30821. Commissioner Brownsy.
Yeah, it just occurred to me, this is your district, so why don't you, I'll second.
No, go ahead. I'm
Oh,
happy with that.
oh,
It's your
okay, you're
last- It's
happy.
your last
Okay, I
meeting.
just
Go
want-
for it. You go for it. Yeah.
I so appreciate that. Okay, I move that the commission issue administrative penalty number CCC-23-8P-04 pursuant to section 30821 of the Coastal Act to Rio Del Mar Beach Island Homeowners Association pursuant to the staff recommendation, and I'm asking for an aye vote.
Second.
Moved by Brownsy, second by Cummings. Could we have a roll call vote, please?
Commissioner Cummings,
Aye.
Cummings, yes. Commissioner Escalante,
Yes.
Escalante, yes. Commissioner Harmon,
Yes.
Harmon, yes. Commissioner Nuttall,
Aye.
Nuttall, yes. Commissioner Rice.
Yes.
Rice, yes. Commissioner Turnbull Sanders,
Yes.
Turnbull Sanders, yes. Commissioner Uranga,
Aye.
Uranga, yes. Commissioner Wilson,
Yes.
Wilson, yes. Commissioner Aguirre,
Yes.
Aguirre, yes. Commissioner Bochco,
Yes.
Bochco, yes. Commissioner Brownsy.
Aye.
Brownsy, yes. Chair Hart.
Yes, with that vote, the motion passes, resulting in the adoption of the resolution immediately below on page 19, the issuance of the administrative penalty. And we'll now move to motion number 3,
Thank you.
administrative civil penalty action under section 30821.3.
Thank you, Madam Chair. I move that the commission issue administrative penalty number CCC-23-AP3-01 pursuant to section 30821.3 of the Coastal Act to Rio Del Mar Beach Island Homeowners Association pursuant to the staff recommendation. I'm asking for an aye vote.
Second.
Moved by Brownsy, second by Cummings. May we have a roll call vote?
Commissioner Escalante,
Yes.
Escalante, yes. Commissioner Harmon,
Yes.
Harmon, yes. Commissioner Nuttall,
Aye.
Nuttall, yes. Commissioner Rice,
Yes.
Rice, yes. Commissioner Turnbull Sanders,
Yes.
Turnbull Sanders, yes. Commissioner Uranga,
Aye.
Uranga, yes. Commissioner Wilson,
Yes.
Wilson, yes. Commissioner Aguirre,
Yes.
Aguirre, yes. Commissioner Bochco,
Yes.
Bochco, yes. Commissioner Brownsy,
Aye.
Brownsy, yes. Commissioner Cummings,
Aye.
Cummings, yes. Chair Hart,
Yes.
Hart, yes. The vote is unanimous.
All right, passage of this motion that we have just voted on results in the adoption of the resolution that's immediately below the the motion in the staff report and the issuance of an administrative penalty. We'll now move to motion for the cease and desist order.
Thank you, Madam Chair. I move that the commission issue cease and desist order number CCC-23-CD-06 to Gaurav Singh and Sanal Puri pursuant to the staff recommendation. I'm requesting an aye vote.
Second.
Moved by Brownsy, seconded by Cummings. Could we have a roll call vote, please?
Commissioner Harmon,
Yes.
Harmon, yes. Commissioner Nuttall,
Aye.
Nuttall, yes. Commissioner Rice,
Yes.
Rice, yes. Commissioner Turnbull Sanders,
Yes.
Turnbull Sanders, yes. Commissioner Uranga,
Aye.
Uranga, yes. Commissioner Wilson,
Yes.
Wilson, yes. Commissioner Aguirre,
Yes.
Aguirre, yes. Commissioner Bochco,
Yes.
Bochco, yes. Commissioner Brownsy,
Aye.
Brownsy, yes. Commissioner Cummings,
Aye.
Cummings, yes. Commissioner Escalante, Yes. Escalante, yes. Chair Hart,
Yes.
Hart, yes. The vote is unanimous.
Thank you. Passage of this motion results in adoption of the resolution below it in the staff report and issuance of the cease and desist order. And now we'll move to the final motion, motion 5, which is now going to be on page 21.
Thank you, Madam Chair. I move that the commission issue administrative penalty number CCC-23-AP-05 to Gaurav Singh and Sanal Puri pursuant to the staff recommendation. I'm requesting an aye vote.
Second.
Moved by Brownsy, seconded by Cummings. Could we have a roll call vote, please?
Commissioner Nuttall,
Aye.
Nuttall, yes. Commissioner Rice,
Yes.
Rice, yes. Commissioner Turnbull Sanders,
Yes.
Turnbull Sanders, yes. Commissioner Uranga,
Aye.
Uranga, yes. Commissioner Wilson,
Aye.
Wilson, yes. Commissioner Aguirre,
Yes.
Aguirre, yes. Commissioner Bochco,
Yes.
Bochco, yes. Commissioner Brownsy,
Aye.
Brownsy, yes. Commissioner Cummings,
Aye.
Cummings, yes. Commissioner Escalante, Yes. Escalante, yes. Commissioner Harmon,
Yes.
Harmon, yes. Chair Hart,
Yes.
Hart, yes. The vote is unanimous.
Thank you. The passage of this motion has now resulted in adoption of the resolution immediately below motion 5 in the staff report and the issuance of the administrative penalty. And that concludes all of the motions. That concludes the hearing on this matter. Thank you.
Thank you very much, Commissioner.